tak terbuat last week, ingat tak? Dismissal for one of prosecution, ingat tak? Kau tak ingat kan I pun? I belum ajar kan?
Yang mana doktor?
Last week kan ada satu topik I belum buat lagi. Dismissal for one of prosecution. I tak buat kan?
Belum.
Okay. Alright, so basically yang order 7 tu at any time application order for a discovery of a particular document. Kalau rule 3 tu rule 7. Kalau rule 3 ni in order to be relevant. Okay. Okay. Wow. Ada yang dia specify lah. Dia particular ni. Kalau rule 3 tu untuk discovery selalunya there must be a document yang relevant yang has been in the possession or custody of against the other party. Okay, kalau misalnya yang kalau discovery order time tu untuk sesuatu dokumen tertentu. Dia ni. Ni. Kalau dokumen tertentu ni betul lah. Rule 3 tadi yang general discovery Ashraf. Rule 3 yang order 24 rule 3 tu ialah application for discovery before the pleading is closed. So basically kalau you tengok order 24 rule 3 ni dia dia kena discovery list of document in the possession of his possession or custody or power. Okay, and also order to make him and file an affidavit and a copy to serve a copy to the other party. Okay. Tetapi the requirement is that rule 3 does not require a party to file an affidavit for general discovery. Kalau tengok order 24 rule 3 tu, subject to the provision of this rule, the court may anytime whatever, okay, originating summon to give discovery by making and serving it on the other party a list of documents. Okay, and may blah blah blah, itulah apa yang dia nak on the other side. Okay, that is order order 24 rule 3. Order 24 rule 7 ialah is a specific discovery order. Order for discovery is sought under this order after pleadings have been closed. Kalau misalnya order 24 rule 3 tu before the pleadings is closed. Okay, rule 7 tu after the pleadings have closed. Okay, under this order, under rule 7 tu the court may order the party to produce such document as the court thinks fit. Boleh? So basically order the 24 rule 3 applied before the pleading state is closed, and order 24 rule 7 is applied after the pleading date is closed. Tengok, kalau tengok wording dia tu sebab tu penting tau. Ashraf tengok wording of the order tu. Dia kata subject to the provisions of this rule and rule 4 and 8, the court may at any time order any party to a cause or matter, blah 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 blah. Semua tu. Alright. Kalau order then to a cause or method to give the discovery. Kalau rule 7 tu, the court may at any time on the application of any party, to make an order on the application of the party. Yang figure tu before the pleading is closed. Boleh Ashraf? Ashraf, you dengar tak?
Boleh, insyaAllah. Boleh.
Okay, so clear lah. So kalau misalnya general discovery order is under order 24 rule 3 and before the pleading is closed. Kalau misalnya pleading dah close, you need to get to do it by way of affidavit by order 7. 2 is request for a specific document. Okay. Now, last week kita dah buat dismissal for one of prosecution. I tak share ni lagi kan, slide ni kan. Dismissal. Slide ni ada dekat dalam notes. Tak banyak. 3. 4 before discovery. Okay, ni apa bendanya dismissal for one of prosecution. So I nak tekan mana? I nak tekan. Mana I nak tekan ni? Window. Desktop kan? Kau tekan ni. Aku punya ni pula keluar. Sekejap. I tekan ni, nampak tak? Malaysian litigator, nampak?
Nampak.
Prosecution.
Betul.
Okay,
Nampak.
Copy paste sekejap. Ni yang simple notes. Kau orang baca nota I mesti kau tak faham apa benda. Nanti I letak dekat chat boleh? I letak meeting chat dia punya link tu. Okay, ni yang simple punya. Nanti kau pening-pening cakap apa lah benda ni merapu ni. Apa benda ni cakap dalam kelas tak faham. Okay, ni term dia ni quite a favorite exam area tau. Dismissal for one of prosecution. Buka lagi tadi I nak buka tak boleh ni. Nasi Simran tak ada. Kau kat depan I kau tak suruh dia buka kan. That's no. Sorry. Dismissal for one of prosecution. Ini ialah an action that is brought by a plaintiff that may be dismissed for one of prosecution. Maksudnya the plaintiff is found to be guilty of intention and contumelious default. Contumelious default or when there has been inordinate and inexcusable delay in the prosecution of the action. Nampak tak keywords dia? Apa keywords dia kat situ? One, okay. One lagi.
Guilty of intention and contumelious default.
Intention, contumelious default. Lagi? Apa lagi wording dia?
Inexcusable delay.
Inordinate and inexcusable delay. Ni benda-benda ni I cakap sebab kan kadang-kadang bila you tengok kertas soalan macam-macam perkataan kan, lepas tu you don't know what is the issue of the question. So bila I cakap keyword dia for you to detect. Apa isu dia sebenarnya? So bila ada dismiss for one of prosecution, kalau you jumpa perkataan ni guilty of intention and contumelious default and that there has been inordinate and inexcusable delay in the prosecution, so we are talking about dismissal for one of prosecution. This is the defendant application. So basically they want the case to be, the prosecution to be dismissed. Okay, the court attitude in dismissing claim for one is prosecution. Basically, is founded upon the claim that it discloses a substantial risk that it was not possible to have a fair trial or likely to cause serious prejudice to the defendant. Okay, so apa yang penting dalam tajuk dismissal for one of prosecution ialah apa itu dismissal one of prosecution? Apa maksud dia? Maksudnya ni lah. Okay, all this. And then what is that next more important is the circumstances that in which an action is dismissed for one of prosecution. So basically, ini favorite area kalau dia nak tanya. There are basically two circumstances. One is under the Rules of Court 2012 and another one is under the inherent jurisdiction of the court. Okay. So basically
Kiranya macam si plaintiff ni dia ada intention untuk delaykan dia nak prosecute case dia tu. So court dismisskan lah macam tu ke?
Bukan court dismisskan, is the defendant apply to the court. The court boleh dismisskan lah kan. Court boleh dismisskan sebab inherent, the second part is the inherent jurisdiction of the court kan. Tapi
so defendant
defendant also can apply to the court for the case to be dismissed for one of the prosecution. Circumstances dia atau grounds dia adalah dalam Rules of Court 2012. Boleh? Okay, so kita tengok balik tadi. So kalau under Rules of Court 2012, these are the grounds. Order 19, Rule 1, failure to deliver statement of claim. Order 24, Rule 16, failure to make discovery of documents. Order 26, Rule 7, failure to answer interrogatories from the defendant. Order 34, Rule 7, failure to set the action for trial. However, the list is non-exclusive. Ada some authors dia ada lagi banyak lah list dia. Dekat notes saya.
Kasi aku kena beli baju yang mas-mas. Kawan. Ya. Aku kena beli.
Wafi, you tanya ke you tertekan tu? Okay. So basically under kalau misalnya action tu began by originating summons, plaintiff action may be dismissed for one of prosecution if he fails to proceed with dispatch under Order 28 Rule 10. Okay, this is under Rules of Court. Another one is under the court inherent jurisdiction. Ni two leading case. Leading case ni kena ingat, even dalam note saya pun ada. Satu, the case of Burkett and James, 1977. So, the court set out the general rule when dismissing an action for one of prosecution before the limitation period expired. Okay. The court have before the court would have no power to prevent. Kalau limitation period had not expired, the plaintiff can start a fresh action. Kalau dah expired, dah tak boleh lah. Okay, the court further held that the limitation period had not expired was a conclusive reason for refusing the dismiss the action that was already pending. Okay, so another issue is that when there are special circumstances where the court satisfied that there will be risk of injustice in allowing the action to be brought to trial, so the court may exercise its discretion to dismiss the action. Okay, that is by virtue of Burkett and James, 1977. In the case of Sheikh Omar bin Sheikh Mohammed and Perbadanan Nasional Berhad 2013. Okay. Order 34 which provides pre-trial case management. The court is said to have a proactive role in setting the timetable for progress of the case. So basically kalau kita tengok pre-trial case management tu lah dia macam set a timetable for the progress of the case. So the parties in the proceeding are no longer given the freedom to move litigation. Maksudnya ada set date, so dia tak boleh sesuka hati lambatkan case lah. But the issue arose was whether the Burkett-James principle was applied where the High Court acted in own motion to strike out an action under Order 34, or whether the second suit was an abuse of the process of court. So we see, macam soalan tadi, Alia kata boleh tak court acted in own motion to strike out, so the court can do that. Okay, so basically in this Sheikh Omar, the court held that the principle in Burkett and James had no application where a dismissal was granted at the court's own motion. So basically the second suit was an abuse of the process of court. Okay, so however it should be noted that Burkett and James principles still apply to other direction but not under Order 34. Order 34 tu apa? Tengok. Confused. Order 34 apa?
Modes of trial. Modes of trial.
Mode of trial. Tu order 33 lah. Kau ni pandai kau kelencong. Kau buka.
Pasal PTCM.
PTCM. Pre-trial case management. Okay. So basically, when the plaintiff comments an action against the defendant, he is expected to litigate the matter judiciously and expediently. So litigants are no longer given the discretion to move the case at their own pace. So Order 34 ni pre-trial case management marks a radical change from the traditional approach where previously it was left in the hands of the parties. So court is now vested with the discretion to control the progress of the case. Itu secara simple apa maksud dismissal for warrant of prosecution. If we look at last week slide, nampak ke? I move ni nampak tak? Slide, tak nampak Dia
Sekarang dekat website tu lagi, Malaysia Litigator.
Okay, sekejap nampak? Dismissal for warrant of prosecution nampak?
Okey dah.
Okey, nampak.
Yang I cakap tadi, under ROC, it can be under Order 19, Order 30, Order Rule 2, Sub Rule 3 ada. In all these cases, Syed Mahathir kalau ada masa lah, tengoklah. Negara Properties, Hong Kong, Ferozan, Syed Omar yang I discuss ni, Syed Omar dengan Burkett and James. Syed Omar tu basically they discuss about the inherent jurisdiction of the court. And then ni inherent tadi first is under ROC, second is under inherent jurisdiction. Burkett and James I discussed just now, and in this case Toh Hock Tai and others and Toh Chiu Biao. So basically in this case Ali Abbas we propose for the purpose of this appeal to state the principle which would guide us in deciding this appeal to be thus that the plaintiff action is liable to be dismissed for warrant of prosecution when the court is satisfied, number one, the plaintiff default has been intentional and contumelious, and number two, the plaintiff or his lawyer is guilty of such inordinate and inexcusable delay that the defendant has been prejudiced by it. Nampak? Keyword dia, intentional, contumelious, inordinate, inexcusable, so you know exactly they are prejudice, what they are talking about, dismissal for warrant of prosecution. So tu cara-cara dia lah, antara trik ya. Antara trik you all nak tahu what the issue is all about. Okay, you tengok apa keyword dia, and then you know it's talking about dismissal for one of prosecution. And then ni contumelious conduct. So basically is contohnya disobedience of a preemptory order or abuse of the process of the court. Okay, position while limitation period has not expired. Okay, where the limitation when the limitation is irrelevant, the new action will be abuse of process of court. So we see that ada kat situ. So we see that these are among issues kita nak plead for dismissal for one of prosecution. So if it non-contumelious, SP could bring a new action. Is it proper to dismiss? So basically in this case, not deploying Burkett, he held that a conclusive reason for not dismissing. So kena tunjuk contumelious conduct lah. Kalau limitation period not set in, actually it gives the right of the plaintiff to bring again a fresh action. Kalau it's not contumelious, so you nak dismiss for one of prosecution, the court might held that it's a conclusive reason for not dismissing. Okay, so other cases are Wong, Mensente, Chung Ai and Federal Court. Okay, these are the cases kalau if you want to do your own reading. So are you clear what is dismissal for one of prosecution is all about? Boleh tak? Okay, dia boleh jadi satu soalan 7, 8 markah ke 15 markah juga tu. On its own or part of question. Okay, now this week, I buka slide baru, nampak tak?
Nampak.
Week 6 kan? Okay, proceedings at trial and evidence. Nampak kan? So
nampak lagi. Masih slide pertama kan ke? Ke orang lain nampak?
Alah, jangan.
Civil procedure 2.
Jangan.
Slide satu lagi kata tak gerak.
Tak gerak.
Week 6. This one. Ni baru week 6.
Okay dah. Dah.
Lah. Hai nak. Dia. Asal dia tak full? Asal dia jadi macam ni? I kena tutup ni. I tutup ni. Alamak. Nampak kan? Okay. Ni, these are my important cases. Last week we do mode of trial kan? So bila it comes during the trial, what will happen? Okay, so these are among important issues lah. Yang I touch in class ni basically important issues when in discussion and also exam purpose lah. Maksudnya issue yang raised tu, it can be a problem question or it can be an essay question. Okay. Order 35. What will happen if during the trial both parties absent? Absence of a party. This is governed by Order 35 Rule 1. Tengok. Order 35 Rule 1. Order 35 Rule 1 dia cakap apa?
Order 25 ROC ke doktor?
35 ROC.
Right.
Pasal failure to appear.
Okay, failure to appear by both parties or one of them. Okay, the general principle is that the court will have the ultimate discretion. Okay, it can make any order it thinks fit. So it may dismiss or strike off the plaintiff's suit. So basically, bila the suit is strike off by the court, the plaintiff can, number one, apply the reinstatement of the case under 35, Rule 2, Sub Rule 2. Okay, when the case is being dismissed or strike off by the court, the plaintiff may apply for reinstatement under Order 32, Rule 2, Sub Rule 2. So it must be, the application must be made within 14 days from the day the case was dismissed. Application is by way of a notice of application supported by affidavit. Affidavit must state the reasons why the plaintiff was absent from the court on the date fixed for trial. So there are certain considerations the court must take into account. So look at Order 35, Rule 2, Sub Rule 3. Tengok Rule 2, Sub Rule 3. Itulah consideration dia. Okay. Interest of justice. Apa lagi? Whether the absence of the applicant was deliberate or due to accident or mistake, the prospect of success of the applicant, there is any delay, and then the conduct of the applicant who has caused prejudice to the other party which cannot be compensated by an order of cost. Okay, these are among the important consideration. Okay, kalau nak jawab soalan kan, let's say the question asks what will be the consequences or what the plaintiff can do if the case is being dismissed if the parties did not attend trial. So how do you go about answering it? Okay, you look at Order 35. Okay, Order 35, you start with Rule 1 and then Rule 2. Okay, so you two mean the plaintiff lah, apply for reinstatement. The case is New Insurance and Karam Singh. Okay, Gil J held in this case that the court was not functious official on the issue raised by the plaintiff as it had not determined the real issues between the parties. The judgment in favor of the respondent was set aside. So if the application for reinstatement fails, the plaintiff can appeal to the higher court. Okay, in cases of reinstatement, the higher court will usually refuse to intervene with the decision of the lower court unless there is a manifest application of error to the fact. So if the case is dismissed or strike off, appeal court won't rarely, they will usually refuse to intervene. If the appeal fails, the plaintiff has to file new action provided that the limitation period has not expired. Okay?
Doktor, kiranya under Order 35 ni kita kan court akan bezakan lah antara striking out a case, a suit ataupun dismiss dia.
Order macam mana? Sama ada striking out the case ataupun
dismissal. Macam mana nak tengok beza dia, doktor, ke tak ada beza?
Dia sebenarnya striking off dengan dismiss sama je. Cuma dia punya terms dia tu maksudnya,
sebab saya confused. Contoh macam kalau strike out, case tu boleh di reinstated. Kalau dismiss, dia boleh di appeal. Jadinya nakkan macam penjelasan macam mana nak draw the distinction tu. Nak clear communication je lah. Saya confused. Sorry.
Okay. So maksudnya kan macam ni, dia punya terms tu dismiss ni dia ada ni,
Peluang
ada
untuk appeal.
strike out tu strike out habis. Dismiss ni dia ada dismiss for non-appearance. We are not now we are talking about dismissal for absence kan, absence of parties. So basically dia dismiss. Okay, dia dismiss.
Oh, kiranya sebab dia tak datang, so kes tu di dismiss, so dia boleh appeal lah.
Dia boleh appeal
Sebab
lah.
kiranya kes tu ada merit lah kan. Tapi kalau strike out tu yang reinstated tu kiranya kes dia tak ada merit. Macam tu ke?
Oh, itu ke soalan you sebenarnya. Tengok merit ke. Sebenarnya bila merit ke tak ada merit tu sebenarnya dia belum, I rasa court pun belum tengok lagi. Dia pun belum, apa orang kata, dia belum, court pun belum buka lagi kesnya. Dia tengok je sebab tak datang. You faham tak?
Oh, faham.
Nak tengok apa beza dismiss dengan strike off kan?
Sebab doktor, kalau dalam buku Ravi Niko ni kan bab yang tidak kehadiran parti ni, nak setting side order made in the absence of one party tu kan. Dia macam ada satu subtopik pasal differences between striking out and dismissing a suit tu yang macam tertanya tu. Tapi tak apa. Ni mungkin baru initial kan kita ni kan. Apa?
So selalunya dia
isu,
dia kalau misalnya ni, I pun sebenarnya kan bila kita practice kan macam I lah, I tak pay attention sangat dia dismiss ke strike out. We know that the case has been dismissed tu macam it's a general, apa orang kata, general terms lah. Kalau strike out tu kadang-kadang ada strike out because of, itulah I pun not sure dia punya terms dia tu. Nanti I check balik Alia, tapi the terms yang digunakan selalunya dismiss lah. Yang strike
sebab kat dalam
buku Ravi Niko kan.
Sebab dia cerita pasal order 35 tu juga. Dia terangkan order 35 tu kan pasal failure to appear tu kan, pasal absence tu yang macam tertanya tu kalau ada beza lah. Tapi tak apalah, tapi so far faham lah kiranya kalau diorang tu tak datang consequences dia macam mana macam tu kan. Faham? Alright, tak apa doktor. Jom kita sambung.
Okay, nanti kita sambung yang tu So basically tu satu. Lepas tu kalau misalnya plaintiff present tapi defendant absent, general rule lah yang you kena ingat. General rule yang bila absent ni, general rule is the discretion of the court. Dia bukan discretion, dia ada word dia, the ultimate discretion of the court. The court may make or they edit things fit. That's the general statement. Kalau defendant pula absent, the general rule is that the court again has the ultimate discretion. If the court may give judgment to the plaintiff. If the plaintiff has a counterclaim, the court can dismiss his counterclaim. If the defendant has a counterclaim, tengok sini, the court can dismiss his counterclaim. Okay. So, if this happen, defendant too can apply to set aside the judgment that has been entered against him. He can also apply to reinstate the counterclaim. It's governed by Order 35 Rule 2 Sub Rule 2. And then again, application must be made within 14 days from the day the court gives judgment. If the plaintiff is absent, the court may dismiss the suit altogether. If the defendant has a counterclaim, the court may enter a judgment against the plaintiff for the counterclaim. Okay? If the defendant has a counterclaim, the court may give judgment against the plaintiff for the counterclaim. I ulang 2 kali. So, you faham tak? So, maksudnya mana-mana parti yang tak datang tu, any claim, any suit, application, any suit or counterclaim will be against them. That's in short. Boleh? Yang counterclaimnya, defendant. Kalau dia tak datang, counterclaim dia gone. Boleh? So the plaintiff should give reasons why he is absent. If he feels he should file a fresh action, provided that the limitation period had not set in. So the plaintiff can apply for Order 35 Rule 2 for the counterclaim entered against him to be set aside. Ini what the parties can do. Okay? Ini apa yang parti-parti tu boleh buat. Good reasons is essential. Okay. These are the things that we mentioned just now. So kena bagi good reason. Next, that I mentioned just now, appellate court will not interfere unless it can be demonstrated that the refusal resulted in the deprivation of essential justice. You can have a look at this case on your own. Okay, these are practice direction. If you can get hold of it, kalau you ada time, look at this article, waste of court time and all that. Okay, cause of trial. Right to begin. Ni proceeding at trial. Belum adjournment lagi. Proceeding at trial is governed under Order 35 Rule 4 Sub Rule 1. So the judge has absolute discretion to decide who has the right to begin in trial. General rule is the plaintiff will start because he bears the burden to prove his case. This is provided under Order 35 Rule 4 Sub Rule 2. Tapi ada exception when the defendant is entitled may have the right to begin. Okay, this is pursuant to Order Rule 4 Sub Rule 2 where the burden of proof is all on defendant and then the defendant is entitled to begin. There's this case, Law Key On and Tanjung Aru. In this case, defendant in the case bore the burden to prove his case since he alleged that the plaintiff had carried out illegal massage activities. So dia kena prove illegal activities, massage on part of the plaintiff. Okay. So basically, the overriding rule is that the court has the ultimate discretion who should begin. Exceptional case, defendant will start. Okay, the case just now Law Key On because he bears the proof of proving the illegal massage thing. Order of speech. So order of speech, like I said, if we may have a chart, dalam Ravi Niko ada chart kan? Nanti you tengok dalam Ravi Niko punya book, dia ada chart macam tu. So basically, this is governed by Order 35 Rule 4. So basically ada it depends on two situations. Situation when defendant elects to call evidence under Order 35 Rule 4 Sub Rule 4, and then the other when the defendant elect not to call evidence under Order 35 Rule 4 Sub Rule 3. So when a party elects to call evidence, it means that he will call witnesses to present his case. You're going to do witness statement kan? You are doing it in advocacy kan? Those ni kita punya proceedings at trial tu lah. It cover the procedural part. So basically when the plaintiff start, when P begins, okay, what he does is basically he briefly refer to the fact of his case and the fact which is in dispute. Okay, apa fact in dispute kan? And then that is in the plaintiff opening speech, and then he will call his evidence or witnesses one by one, and then defendant will cross-examine each of the plaintiff witness. This is the sequence. After that, the plaintiff may re-examine the witness. Plaintiff call witness, defendant cross-examine, plaintiff re-examine the witnesses, and then after that he may rest his case. Next, defendant will open his case by giving him his opening statement. He will call evidence or witness, and then afterwards, plaintiff may cross-examine the defendant witness, and then the defendant re-examine his witnesses, and then after all that, he call all of them, and then he make his closing speech, and then the plaintiff make his closing speech in reply. Okay, so next question is, when plaintiff is making his closing speech, can the defendant answer or reply to the speech? Generally, this is not allowed. There should be no reply at that stage. The exception is under Order 35, Rule 4, Sub Rule 2, which says that in the closing speech, when the plaintiff raises new point of law or cites new authority, the defendant may reply only to that particular point of law or new authority. That's only the exception. Okay, so in practice, when all the defendant has called all his witnesses, the court will ask for a written submission from both parties. Okay, and then a date will be fixed for submission. There will be 3 submissions: plaintiff, defendant submission, and the plaintiff reply to the defendant submission. Okay, that's in practice. So you can later further ask your practitioners how's the practice about order of speech and the written submission. Okay. Calling our witness, I've covered just now. Counsel right of charge, you have time, you download all this. There are 3 articles, cuba download nanti and put in our here or in our Facebook, in this Teams or in the Facebook. And then witness statement, you are going to do that in your advocacy kan, witness statement thing, order 34, order 38. Okay, witness evidence, the type of evidence. You have done evidence. Basically, there are a few types of evidence. Witness, 1. This is governed by Order 38, 39, 41. But Order 38 governs about witness. 39 is on the position, statement of the witness out of court. Order 49 is affidavit, the sworn statement, the one that you usually do. And then another type of evidence is documentary evidence. So documentary evidence, and there will be agreed bundle of documents, disputed bundle of document, and statement of agreed facts. And I guess you have done it right in your advocacy. Okay, these are important cases that you should know. Okay, so next is submission of no case to answer. Application to rule of judges. Okay, submission of no case to answer. This is again one interesting part. So submission of no case to answer. Remember, in your criminal, once the plaintiff has established a case, and then he's established what? The prima facie case. Tapi dalam civil, okay, ni term dia famous, known as submission of no case to answer. So basically, he cannot make up his case. The plaintiff cannot make up his case. Okay, so it may be made by the defendant, either if no case has been established in law or the evidence lead is unsatisfactory or unreliable. Itu maksud submission of no case to answer. The main case is UL and UL. So basically, the submission made by the defendant, the judge should generally refuse to such submission unless defendant made it clear that he does not intend to call evidence. Okay, the case of civil is burden of proof is on the balance of probabilities. So if he could not establish his case, the defendant may later make a submission, I have no case to answer, I don't intend to call witnesses, to call evidence, meaning that the case is weak against him. The court is not bound to follow, so to review, it does not put a defendant to put his election or whether to call plaintiff or not, to call evidence or not, defendant retains his right to call if its submission fail. Okay, the reasons behind this rule, all this, okay, Jafar Shari, Siti Jamal Hashim. Okay, this is again application to reopen case. You can read it on your own. Trials before inquiry and assessment of damages. So these are the role of judges in civil trial, advisory process. So basically, civil trial is different from a criminal trial. So basically, the court the criminal, they are more adversarial. Both actually are adversarial, but it's hostile, more hostile compared to civil. Okay, and there's one part that I don't cover is adjournment. Why it's not here? Adjournment of trial. Ada adjournment of trial. This is another issue, quite an interesting area. Okay, so basically adjournment of trial is covered under Order 35, Rule 3. So basically, the trial began and then one party seeks for adjournment. So principle is that court will consider whether to grant or not based on either interest. Justice, they must give good reason to support request for adjournment. Okay. Okay, so basically adjournment reason, for instance, important witness is missing, key witness is ill, counsel himself is ill. Okay, there's this case Lee Ati. Okay, the refusal of adjournment because there were many adjournments before. Okay, so the court refused to give adjournment. Okay, so when the court refused to give adjournment, the general principle is that the judge must come to his decision very carefully because it has very serious consequence on the party. Okay. So, evidence by witness we have covered. Subpoena. Okay, subpoena is it's not in here. So basically, subpoena is an order for court to compel witness to attend court to give oral testimony or produce a document. If you don't comply with subpoena, it is a contempt of court. Alright. So I guess that's all the main part of this topic. Okay, any question? Ada soalan tak? I dah running out of time. Apa Ashraf? Satu minit je tu I ada ni. I nak
ada. Siapa nak tanya dulu?
Okay, cepat tanya.
Saya dulu lah. Ada orang. Madam, saya nak tanya tapi bukan berkenaan tajuk ni.
Apa benda
kelas saya kan dengan practitioner Madam Pavani tu.
Kenapa?
Dia minta tolong saya untuk tanyakan pada doktor bagaimanakah proses hearing tu akan dilakukan.
Bagaimana? Terpulang pada dia. Dia simple je punya hearing, bukannya yang complicated. Apa maksudnya? Dia korang bagaimana? Macam mana kau punya soalan ni?
Macam mana proses hearing tu akan dilakukan? Kalau dalam online ni, madam nak 4-4 bercakap ke?
Apa rubrik marks tu?
4 group ke apa?
Group lah. Group kan?
Sebab satu form kan 4 orang madam. Semua dalam tu kan defendant. So 4-4 tu ke kena cakap madam?
4 defendant?
Kan satu firm 4 orang.
4 orang tu, 4 orang tu. Yelah.
Semua kena submit.
Tu akan bercakap.
Kau kena bagi-bagilah point.
Okey, baik. Okey, nanti saya faham.
Nak markah kan, nak markah individual kan. nak markah individu juga for your marks. Okay, ada lagi soalan? Ada. Okay.
Slide madam ni, madam upload dekat Goals ke?
Belum. Nanti I upload kat sini kejap. Kat sini pun boleh. Aku dah kelang kabut.
Ya. Dengan slide yang tadi pasal dismissal action for one of principal tak, yang tu based on artikel kan?
Notes yang minggu lepas I dah bagi. Yang I cakap dismissal for one of prosecution tu minggu lepas. Slide dia. Dapat tak? Okay? Boleh? Okay, apa-apa kalau tak tu simpan soalan next week dengan soalan aliyah tu Okay? Sorry, I have to rush. Okay, apa-apa kita cover apa-apa yang tak kelang kabut this week, kita cover next week pula. Okay, notes saya dah bagi, nanti I bagi tutorial question list of cases. Sorry for in hurry. See you next week. Assalamualaikum. Bye. Take care. Stay safe. I kena leave
Waalaikumsalam.
Thank you, madam. Dah.